Hi everyone, welcome to this brief explainer video on jurisdictional and non-jurisdictional facts, which is a really important issue thinking about unauthorised decision making and the times or the circumstances under which we might ask for judicial review of a decision that we think might have been unauthorised. So we'll start with the decision as always, and the classic formulation of administrative decision making, which is if X exists, Y may do Z. So if a particular fact exists, the decision maker may do a particular thing. And to explain the difference between jurisdictional and non-jurisdictional facts, we'll work through two example sort of scenarios or authorities. The first is if a person travels to Australia from overseas, the Chief Health Officer may require them to undergo quarantine for 14 days. The second example is a little bit different. If, in the opinion of the Chief Health Officer, a person is likely to be affected by COVID-19, the Chief Health Officer may require them to quarantine for 14 days. So, two examples, and we'll refer to them as we go throughout this video. You'll remember from our discussion of judicial review in general that the general principle is that judicial review is not interested in factual errors or questions of fact. We're focused on the process by which a decision is made, not necessarily the actual decision itself. The exception to this is where a decision maker's authority is contingent on a particular fact. So, in the scenario, if X exists, a decision maker's authority only arises if X in fact exists. And so when we're interested in judicial review about the process by which a decision was made, the existence of X is a threshold question to decide whether the proper procedure has been followed and things like that. And so the court does become interested in that particular factual question. So how do we know if a particular fact is jurisdictional or not? How do we know whether a fact is jurisdictional or non-jurisdictional? We can ask ourselves a relatively simple question. Does the authority arise because of the existence of a particular fact, which would be jurisdictional? Or does the authority include the power to decide whether the fact exists or not? And I use exists in sort of inverted commas there because there's discretion involved, and that would be non-jurisdictional. Another way of expressing that is X determined objectively or subjectively? Is this a fact that we can objectively determine or not, or is there discretion involved? So to apply our first example, if a person travels to Australia from overseas, the Chief Health Officer may require them to undergo quarantine for 14 days. In this example, X is travelling to Australia from overseas, and that's objective, right? We can clearly tell if someone has travelled to Australia and if they've been overseas. That's a bit of a yes-no question, really. And so when we think about what the Chief Health Officer is, who's Y, can do, Z, they can require someone to undergo quarantine for 14 days, right? That's what they can do. And they can only do that if someone has travelled to Australia from overseas. What they can't do is decide whether or not someone has travelled from overseas or not. And so, obviously the power itself is contingent on the Chief Health Officer being able to recognise whether someone has travelled from overseas or not. But because it's an objective question, the Chief Health Officer doesn't actually get a say in whether someone has travelled from overseas or not. They just have to look at the facts and say, oh, yep, this person has, therefore I've got this authority. Oh, yep, this person hasn't, therefore I don't have this authority. There's no room for the Chief Health Officer to exercise discretion in deciding whether or not someone has come from overseas or not. We can contrast this with the second example, which says that if, in the opinion of the Chief Health Officer, a person is likely to be affected by COVID-19, the Chief Health Officer may require that person to quarantine for 14 days. Here, X is, in the opinion of the Chief Health Officer, someone is likely to be affected by COVID-19. And that's subjective, because that comes down to the Chief Health Officer's opinion, right? Now, that opinion can be guided by other legislation or other provisions within the legislation. So, there might be factors that the Chief Health Officer has to consider in reaching that opinion, whether someone's been a close contact with a confirmed case, whether someone is displaying symptoms or not, those sorts of things. But at the end of the day, deciding whether someone is likely to be affected by COVID-19 or not is subjective and utterly discretionary, and up to the discretion of the Chief Health Officer. So in terms of thinking about what the Chief Health Officer can do, not only can they require a person to undergo quarantine for 14 days, which was the same as example 1, but they actually get to decide if someone is likely to be affected by COVID-19 or not. And that's different from example 1, where the Chief Health Officer didn't get to decide whether the authority applied or not. Comparing these two examples, the first is jurisdictional, and the second is non-jurisdictional. In the first example, the decision maker's authority or jurisdiction is contingent upon X. It only arises if X exists, and X is objectively determined. So the decision maker doesn't get to decide if X exists or not. Comparing that with example 2, the decision maker's authority or jurisdiction includes X. So they get to decide whether X exists or not. They get to decide, they've got the discretion to make up their own mind about whether X exists, whether a person is likely to be affected by COVID-19 or not. And so that's the key distinction, and that's the key way that we tell if a decision is jurisdictional or not. If the decision maker gets to decide whether X exists or not, then it's non-jurisdictional and it won't be judicially reviewable. If they don't get to decide whether X exists or not, it will be judicially reviewable. From a practical perspective, I'll let you guys in on a bit of a secret. Most administrative powers are worded in a way to be non-jurisdictional. As a sweeping generalisation, the government doesn't want decisions to be judicially reviewable, so they'll word things in a way that makes them non-jurisdictional as much as they can. But moving on, just to recap, a jurisdictional fact can be judicially reviewed. A non-jurisdictional fact cannot be judicially reviewed. So if we've got a non-jurisdictional fact, if we can't have that judicially reviewed, what can we do? We've got a few options to think about. The first and most obvious one is to look for merits review instead, because merits review includes all aspects of the decision, including all questions of fact. If we're concerned about a non-judicial fact, merits review should be the first port of call. Now, it's worth remembering from week 3 that merits review is only available if the Primary Act allows it. So there's no guarantee that you do get merits review. You need to check the Primary Act, but it's a fantastic starting point. Other avenues might be to look for no evidence as a separate ground of review. So there's no evidence at all for this decision. And you can check out the week 6 content for more details on that. But broadly, the argument would be that it's not a question of whether the decision was authorised or not, or whether the decision maker had the power to make that decision. We're actually arguing that there's just completely no evidence on which to base this decision at all. Another option would be to look at unreasonableness, which we'll look at in week 10. So this idea that this decision is so unreasonable that no decision maker would have made it. And so here we're not too worried about whether the authority is there or not. We're not too worried about whether a fact was jurisdictional or non-jurisdictional, because instead we're just arguing this decision is so woefully bad that it just can't stand. But stay tuned for the week 10 content for more details on that one. thanks very much for watching. I hope this helps clarify what can be a really tricky area of law. And if you've got more elements of this topic that you are having a bit of troubles with, please do feel free to request a similar video like this. I'm more than happy to provide more content like this one. But thanks for watching. See you next time.